Today we're going to talk about the top 10 myths that exist in family law proceedings. That means the top 10 misconceptions that people have about what it takes to prevail in a family law file. Number 1, it takes an aggressive lawyer to win your family law case. The family law file is dramatic enough. When you have an aggressive attorney, oftentimes that lawyer is bringing in their own sense of drama and personality and ego in the file, and that creates interference. It tires the parties in the file, but it can actually tire the lawyer's client. The aggression is oftentimes uncalled for. It can create a deflating feeling in the file. It can create the feeling of an added obstacle in the way. And there's enough obstacles between the parties that we don't have to add our own personalities to add another layer of difficulty in the file. Number 2, you have to answer every single allegation and counterpunch everything that your spouse has thrown at you. Otherwise, what your spouse says goes unanswered, and that becomes the truth. That's an exhausting way of dealing with a file. You cannot get caught in the punch-counterpunch dynamic of a file for several reasons. First of all, if you're dealing with a party that is engaging in character assassination and that's trying to render a depiction of you that shows that you've done nothing right in life and that you're always wrong, that alone can speak for itself, because that often sheds light on your spouse's tendency to exaggerate and to amplify and denigrate. You don't have to engage. Sometimes by choosing not to engage, you're showing a level of restraint that speaks to your maturity, your sense of awareness, and your sense of not having to defend something that is indefensible. If the sky is blue, you don't have to argue that it's red. We all know that it's blue. You're also going to exhaust yourself if you start dealing with every single accusation that's thrown your way. It's going to make you lose focus on the most salient arguments that will allow you to prevail in your file. The judges ask us to focus on the strengths of the file. You don't have to throw yourself on every single accusation, every single allegation, because then you become as lost as the other side appears to be. So keep your focus. Number 3, I'll quit my job to not pay child support. No, you won't. You're going to keep your job because you can't quit your job and run away from your financial obligations to your spouse or to your children. If you voluntarily diminish your resources to flee your obligations, you'll be penalized because it's a right that's exercised by the parents, but it belongs to the children. Number 4, child support ends when your child is 18 years old. It does not. In Quebec, child support will end when a child finishes studying and has acquired financial autonomy. So what we're hanging our hat on here is studying, the academic project that the child has. Is the child studying in a viable way? Is the academic route working? Is the child succeeding at school? It doesn't mean that your child needs a 4.3 GPA, but you don't have to finance a child's difficulties or unwillingness to pull their own weight in school. You can have an adult child that receives child support who is in school so long as the intent to be serious in school and to gain meaningful employment is there. But I'm not saying that if your child is flunking out, you don't have to pay child support. Children can go through difficulties at school, and it's important to find out why they're struggling and what's making them suffer. That's part and parcel of your obligations towards your kids, is to find out what's wrong and what you can do to set them on the right path, to help them, to alleviate their pain or their suffering. But if there's self-inflicted difficulties, where a child has just chosen to take a path that is just simply not viable. It is not up to the parent to finance that lifestyle. Number 5, I'm going to pay spousal support forever. You won't pay spousal support forever. Spousal support is part of the Divorce Act's objective, which means to have both parties acquire financial autonomy. If there is a weaker spouse as a result of the separation, spousal support is there to remedy that temporary ailment and to give that spouse enough time to get back on his or her feet and to gain financial autonomy. But that's going to vary in function of who the spouse is. Just like severance would vary after someone's lost their job. Severance will be a result of how old the employee was, how much education that person has, how much they were making, how much seniority they had at work, the likelihood of them finding a similar job, and how long that would take. Spousal support is very similar in its thought process. If you've been married for a very long time and you never worked as a result of a decision that both of you made together, then you can expect spousal support to last much longer. You've decided together that one of you was going to be more vulnerable financially. And that means that when that person is on his or her own, there needs to be some kind of a remedial measure taken to make sure that the divorce does not cripple that person financially. Does that necessarily give that person the keys to being able to claim spousal support for life? No. So if the receiving spouse, the spouse receiving spousal support, is in a position to acquire financial autonomy, at some point in time, it will be justified to stop the spousal support. It's clear, however, that if you're 61 years old and receiving spousal support, you could probably expect spousal support if you've been married for a long time to continue until retirement. You don't pay spousal support after you retired because your retirement income or your RRSPs have already been divided through family patrimony. So you're not going to pay from what you've already partitioned. That's what we call double dipping. There's no double dipping. Number 6, adultery is punished. Adultery is punishing, but it's not necessarily punished because there's no fault necessarily in family law or in divorce. It's not because you committed adultery that there's moral blame that could have repercussions on your file. Adultery is something that's taken into consideration, first of all, to shorten the amount of time that you would have to wait to obtain a divorce. You normally have to wait a year since you've been separated to acquire or to ask for a divorce judgment. If someone has committed adultery, you can ask for the divorce judgment right away. But the decision to commit adultery can be reprimanded if that act took the spouse away from the family enough to create a sense of void, abandonment, relinquishing of one's parental responsibilities. If the adultery also had a financial impact, because like it or not, it takes a certain budget to float those lifestyles. And so was there money thrown into the adulterous relationship to nurture it, which in turn impoverished the family? Those are areas where adultery could be reprimanded. 7, my lawyer can fix everything. Trust me, I wish we could. But that's like telling the school principal, I'm paying you to educate my kid who's got problems at school, you figure it out. We can't fix everything. We can't fix everything, for example, because we can't control whether your spouse will obey the judgment that was rendered. We can't fix everything because we can't stop your spouse from saying certain things about you or saying certain things to your kids. We cannot be involved in every compartment of your life. We can't fix it all, but our job is to know when we need to intervene. Because if we intervene at every level, we're depleting you financially as well. We have to know when it's time to get in and efficiently know when it's time to get out. Number 8, I'm the client. I decide. This goes for every type of file, not just family files. But certain clients and family law files feel entitled because it's so personal to them that they're intent on having things done their way. And oftentimes the client is a great guiding light in our files. But lawyers have an ethical duty towards the client. We also have an ethical duty towards the children. We have an ethical duty towards the other side. We cannot betray our ethics in the sense that we cannot take you down a path that we know will be destructive to you and to your family. We cannot take you down futile avenues or abusive paths. We cannot engage in discourse that we know will bring you nothing other than a fat legal bill. We cannot take you down a path that we know will bring you failure. Even if you pay us for it, it's our ethical duty to say, no, there's a limit, because we know that the law will not give you what you want and will not take you where you want to go. We have to be able to decide how to counsel you based on the experience we have. You have the experience about what it's like to be in the family. You have the experience in feeling what you feel within the family dynamics. We then in turn take that experience and use our experience and our knowledge of the law to counsel you and get you to a better place. Number 9, my children don't have a voice, but your children do have a huge presence in the file. You can introduce them into the file through their own testimony, which is an awkward situation because they may feel like they're taking sides or they're being pushed to take sides, and they have to do that in real time in front of the parents. But you can also hire an attorney for the children, and that attorney will meet the children individually, privately, and gauge what the children want. It's the child's attorney's role to extract the child's voice in his or her office, and then to record it and project that voice metaphorically in the courtroom so that the child's wishes can be heard. Number 10, a win is always a win. A loss is always a loss. I've had incidences where a client wins something significant in the courtroom in a family law file and then realizes that that win comes at a cost. There is an opportunity cost to every victory. And sometimes the client feels a sense of remorse. This reminds me of a beautiful scene in the movie Kramer versus Kramer. Probably the nicest movie about family law and custody proceedings that I've ever seen. At the end of the movie, after this massive custody battle, Meryl Streep, the mother, wins custody of a small child. Dustin Hoffman, the father, is left reeling. So she's won in court. And the judgment in court could be rational and reasonable in law. But the damage that it inflicts on the child and then on the father is too large for the mother to stomach and to accept. And so at the end of the movie, spoiler alert, despite having won, the morning where she's supposed to pick up her child, she shows up in tears and tells the father, I can't do this. I can't do this to the child and I can't do it to you. Sometimes a win inflicts far too much damage and actually can feel like a loss. And sometimes a loss is actually a win. These are my top 10 myths regarding family law proceedings. I'm pretty sure you can come up with your own in the comments. Please feel free to do so. Leave any comment you'd like. I'll be happy to answer you. And I'll see you in the next video. Thanks so much for watching.